Vijay sir, you can start.
Yes, Nilima. Thank you.
Thank you.
Good evening, everyone. Distinguished resource persons of the day, Professor K.C. Prasad sir, respected Principal Dr. K.P. Kempagoda sir, my esteemed colleagues and dear participants. I am Dr. Vijay, an assistant professor and coordinator of the present faculty development program. It is my privilege to welcome you all to the day 2 of 7-day faculty development program on new labor codes. Today we have with us a distinguished professor, Professor K. Sivaprasad sir, Registrar, Ramaya School of Law, Bangalore. It is my honor to present a brief profile to you all. Sir, area of interest is the labor law, administrative law, and interpretation of statutes. Sir has delivered several special lectures at various institutions across the state. Sir has published several articles both at the national and international journal. He has presented several research papers at the various national and international seminar and the conferences. So presently, Sir is working as a registrar, Ramaya School of Law, Bangalore. Sir has accepted our invitation and agreed to deliver a lecture on Code on Wages 2019, the challenges of codification of wages laws in India. Sir, on behalf of the Janata Education Societies, Vivekananda College of Law, and all the participants, a warm welcome you, sir. I take this opportunity to welcome our beloved principal, Dr. K.B. Kempagoda, sir, on this occasion. And I also welcome my dear colleagues and dear participants. Over to you, sir.
Thank you very much, sir. Good evening to you all, respected principal, distinguished colleagues. It's my privileged honor to be part of this faculty development program, and the topic that is chosen is the new wage code. Am I audible?
Yes, sir. Yes, sir.
Okay. This new wage code 2019. And there are even other three codes in the form of Industrial Relations Code, Occupational OSH, Occupational Safety, Health and Working Hours Code 2020, Industrial Relations Code 2020, and Social Security Code 2020. In fact, the labor law regarding the ambience of labor laws in India, we have had plenty of umpteen number of legislations at the central level and at the state level. Now to simplify, to bring about some sort of uniformity for the sake of smooth enforcement, for the sake of quality, harmonious industrial relations among the concerned stakeholders, especially employer and employees, different classes of employees. It was already recommended way back in the year 2002 by the National Commission on Labor that the existing labor laws are to be streamlined and we have to introduce some sort of a uniformity as the present existing labor laws are in plenty. They were conflicting since we are living in a federal structure. Both at the central and state level, we have had plenty of labor legislations. This posed huge challenges and many number of litigations have gone from the scratch to the apex, leading to plenty of interpretational issues regarding the labor matters or industrial matters. This led to some sort of the advancement of industry has taken some sort of a back foot. And the growth depends upon the quality relations. Quality relations cannot come that easy unless the legislations existing serves the purpose. The legislation should not be a blot-like. Legislation should not be a hurdle-like. Legislation should be some sort of an asset, some sort of a mechanism, some sort of a vehicle for smooth functioning. Not that earlier legislations were defective, but earlier legislations really posed the threat in view of their presence in abundance. And that led for, whether it is small sector business, whether it is, large sector industries, whatever it may be, they were, first of all, to begin with, they were in confusion regarding, by which legislations we are to be, governed by. What all legislations we are to comply. The compliance issue was a major issue earlier that led to multiplicity of litigations. on the one side, employers organizations, on the other side, employees organizations like trade unions, on the other side, the regulators. From every corner, there used to be some sort of a hurdle for smooth functioning. And in order to overcome research where so many, the debates, the workshops, the symposium, the research were conducted for several years. Though the National Commission on Labour recommended in 2002, but it did not become reality. And instead, the one after another rules or regulations, became mounting and added. That led to some sort of a conflict. That led to some sort of a burden on the employer, because ultimately it is the employer who will be liable for non-compliance. And in order to avert this, to protect the interest of both the employer as well as the employees, and to protect the interest of the nation, as per the recommendations of the National Commission on Labour as well as the ILO, it was resolved somewhat in the later part of the second decade of this 21st century, that there should be an eminent need to bring about these codes. And we have to bring about some sort of a simplification, some sort of uniformity, some sort of a easy access, some sort of easy enforcement regarding each and every spectrum of labor issues. And accordingly, it was felt to enact and reduce the burden on the concerned persons, whether it is the authorities, whether it is the government, whether it is the employer, whether it is the employees. And the result was that into August 2019, they introduced wage code, Indian Wage Code 2019. It was, in fact, notified on the August 2019, and other, labor codes were introduced, rather, notified in the year 2020 in a month of September. But did it become a reality? We were contemplating as to when, and moreover, 2020-21 Corona, intervened, and that further led to the delay in the implementation of these. Though it was notified, but there was a delay in the implementation, not due to that national calamity like the Corona, but that was one factor. And the other factors, conflict between employers and employees. Reasons that whatever the code provisions, whether it is industrial relations, wage code provisions, social security provisions, or the other industrial, what is that, occupational safety, health, and working hours provisions. Each of these provisions had introduced uniformity. Each of these provisions has introduced some sort of serious changes, and that, in fact, threatened, apprehended employers and employee community in respective of some matters. That led to some sort of apprehensions. These apprehensions, went on to in the form of appealing to the concerned government, the central government. Reason that if you would introduce, then it would be a catastrophic approach on the part of the government, on the part of the appropriate government. If it is introduced, then that will burden the industrial sector. Ultimately, you wanted to protect, you wanted to bring about uniformity, you wanted to protect the legal rights of the employer and employees, but that would not be serving any purpose. Reason that you introduce with the burdens, and we are not currently and instantly prepared. So give us time. And since 2020-21, when it were notified, there were many changes introduced, conforming to the reasonable demands of both working section and the employers community. And as a result, on November 21, we have seen that the new codes became a reality, and all the 4 labor codes got implemented. It was notified in 2019 August and 2020 September, 1 and 3 respectively. But in 2025, on November 21, it became a reality, implemented, and that implementation led to the all the earlier existing 29 legislations got subsumed to form 4 labor codes. And these labor codes are very much primarily aiming at to provide, to rationalize, to bring about some sort of uniformity by amalgamating them, so as to bring about some sort of uniform structure regarding pay matters, regarding enforcement matters, regarding the appointment of authority matters, regarding advisory boards, regarding claims, penalties, etc. And we know that many earlier to these labor codes, there existed all these 29 legislation got subsumed, to form, amalgamated to form these new four labor codes. But if you count those 29 legislations, it had in all 1,436 sections, provisions, rules, I mean to say. And with the amalgamation of these, with the simplification, with the subsuming of these many legislations, now we have got 4 labor codes. This resulted in only, I mean, this has reduced the provisions because there were too many overlapping provisions, and as a result, this uniformity contributed a lot. To mean to say, there are about 351 now provisions in these 4 labor codes. Remember, starting from wage code to ending with the OSH code. We have now, instead of 1,436, we have got 351 provisions. And returns to be filed by the employers. Earlier it were 31 based on different legislations, but right now it is single, that too in electronic form, digital form. And the forms that need to be submitted by filling it, earlier it was 181, but right now it is 73. And register to be maintained by the employer in each and every establishment concerning working hours, it may be wage payment, it may be different classification of employer, muster roll, it may be whatever. The register earlier were in all these legislation 84, but right now it is reduced to 8. And registration, earlier all these establishments required registration as per their respective laws, whether it is trade union, whether it is contract labor, whether it is building, whether it is child labor, whether it is what is that called I mean to say unorganized labor sector, unorganized social security act 2008. It had all in its respective provisions. There were provisions for registration and incorporation, but now there is only a single a single medium. And in other words, even the licensing earlier in different enactment, different form of licensing, but now there is a single mode. And the compounding of violations, for example, any contravention made in respect of each and every labor codes, there were contraventions, there were authorities to entertain the claims, and certain claims, certain violations or contraventions were of serious nature, then in which case the serious contraventions would invite both penalty as well as imprisonment. But now it is in the new labor code, it is now more or less compounded. Compounded does not mean that in entirety they have taken away the what is that called punitive measures. The punitive measure is very much there. First imposing hefty penalty, and next one I will get to that in labor in the wage code. But generally speaking, the first one, if at all contravention done, then it will be remedied by way of hefty penalty. But second one, if it is repeated within, then no hearing, and straight away you will be prosecuted before the criminal court, either metropolitan magistrate or judicial magistrate of first class. So these are the provisions. And regarding improvement notice, we have got each and every enactments, so-called Industrial Disputes Act, it may be in the Equal Remuneration Act, it may be Minimum Wages Act, it may be Payment of Wages Act, it may be Factories Act, it may be Maternity Benefit Act, it may be ESA Act, ECA Act, so-called, so forth. There are plenty of legislations. As I mentioned, it is 29 earlier legislations got subsumed to form these 4 legislations. In all these, there were no such notice provisions were there. Provisions for the appointment of inspectors were there. Provisions for the appointment of adjudicating authority were there. Provisions for the appointment of appellate authority were there. And all these were there, but there was no provision for giving a caution like improvement notice. They were giving notice for contravention of the provisions and subjecting you to appropriate penal provisions, whether it is by way of a penalty fine or whether it is by way of imprisonment. But now it is not so. When the first one offense is committed, then you will attract a notice by the concerned authority. He is not called inspector here in our labor codes. He is called inspector cum facilitator. He will definitely enter your premise, but he will give one opportunity after getting to know of the cause of the dispute, the cause of the form or magnitude of the contravention. He will give one opportunity for correction, something like that. So neatly it is organized in these 4 labor codes. And I don't mean to say that in view of this simplification, to bring about the uniformity, it will not pose challenges. It will because right now we, instead of 1486 provisions in all those 29 labor legislations, we have just 351 provisions. But look at these, the 4 labor codes, as you mentioned. Especially the topic of my delivery is wage code. What are the various challenges in the codification of wage laws in India since 2019? Though it was implemented in 2025, but we have to go through the process. And these wage codes, and you know that there were earlier regulating the wages. There were earlier 4 different legislations regarding regulation of wages, namely prescribing the wage, that is Minimum Wage Act 1948. Then second one, Payment of Wages Act 1965. And third one, Equal Remuneration Act 1976. And the Payment of Bonus Act, this Payment of Wages Act 1936, Payment of Bonus Act is 1965. So these legislations, for your information, as we have already gone through, discussed, studied, to our knowledge, that earlier Minimum Wages Act contained provisions like 31 provisions. Payment of Wages Act contained 26 provisions. Equal Remuneration Act contained 18 provisions. Payment of Bonus Act contained 40 provisions. In all, it had 115 provisions. And remember, out of these 115 provisions, there were found to be overlapping in the sense, whether it is Minimum Wages Act, Payment of Wages Act, Payment of Bonus Act, or Equal Remuneration Act. There used to be provisions for appointment of authorities. There used to be provisions for appointment of authorities to, like inspectors, like, claim adjudicating officer, like appellate authority, like advisory boards, different provisions, and even the definitions. Plenty, the very word wage itself, our subject matter is wage code, and it is codified now to form a single code. And the word wage is defined in each and every enactment. Leave alone these 4 wage legislations. In all the 4 labor codes, earlier it were 29 legislations, in each and every legislations, there were definitions of wages, there were definitions of employer, there were definitions of establishment, employee, workmen, etc. And there used to be some sort of a changes in the definitions. Workmen defined in Workmen Compensation Act, or so-called Employee Compensation Act, workmen defined in Minimum Wages Act, workmen defined in Industrial Disputes Act, they were all different. And as a result, that posed challenges to the employer. Some contraventions earlier were due to the existence of abundant laws. When there is, as you all know, that more number of laws present, it means we are living in a weaker society. Less number of laws means we are living in a stronger society. That is what we have studied law in the elementary sense. I mean to say, lesser number of laws is the clear evidence of a higher degree of morality. More number of laws is a clear sign of a lesser degree of compliance. I don't say immorality, lesser degree of compliance. So as a result, to ensure compliance, what we used to do? The legislators, or under their authority when delegated, the administrators, bureaucrats, they used to pass orders, rules, etc. And presence of these many laws and rules, it really caused serious ambiguities in its enforcement, resulting in bringing about this newer codes. And wage code is no exception. It has 115 provisions in all, and it subsumed these 4 provisions, as I said. And Minimum Wages Act, for your information, what all provisions that it had in its enactment 1948, it had definitions, it had provisions for fixation of, revision of, review of minimum wages. It had the clear definition of various forms of wages, like starting from at the base level minimum wage to a degree higher living wage, and then fair wage. Now that itself is a real challenge for everybody. That itself is a real challenge for everybody. In a sense, employer used to pay, he used to continuously pay the minimum wage, though his financial condition improvised year to year. but he never thought of, with a degree of responsibility, he never thought of implementing implementing the concept of living wage or fair wage. Don't you think it is exploitation of workers? That is the one reason that we have now the wage code to bring about uniformity. That was the confusion earlier. No employer would present that, okay, our financial condition has bettered, therefore I can now introduce to my establishment the living wage and not the fair wage. Sorry, and not the minimum wage. We will just inflate to the level of a living wage. And if further improvement happens in the financial returns, then we will go for the fair wage. But that was not happening in each and every establishment, in each every sector. And that led to some sort of resentment among the trade union, among the working community, both at the organized and unorganized sector. Remember, we are living in a economy wherein our economy strongly depends upon industries and agriculture. And in both the phases, whether it is industrial environment or agricultural environment, there it presents a huge chunk of unorganized sector workers. The formal sectors, they are regulated by laws. We have had, of course, the contraventions. We have had conflicts that were of serious nature because of their, being informed about the laws. But look at the informal sectors. They were not protected. There were no social security measures. There were no occupational safety measures. There were no working hours provisions. There were no that minimum wage or payment of wage provisions. That led to serious sort of, impairment of their basic rights. As you know, that the Supreme Court has repeatedly said that right to, minimum wages, right to living wages, they are fundamental right. And under Article 21, and we have got constitutional environment, constitutional ambience as well to promote, to safeguard, to protect the rights of the industries, the stakeholders, especially the working community, like Article 14, like Article 19, like Article 21, like Article 23, like Article 39, 40, 43. Even with the presence of these apex provisions in the Constitution of India, still we have had immeasurable number of disputes, industrial disputes connected to various aspects of industry, starting from the point of appointment till the stage of retirement. Plenty, even after retirement, regarding retirement benefits, administration of benefits, there used to be some sort of disgruntled opinions, views, and as such, that led to further the disputes. To bring about some sort of relief, we have passed these labor legislations. And you know that in the newer wage code, there are plenty of facilities available as far as what is that introducing important provisions that were present in the earlier legislations, like minimum wages act, like payment of wages act, like equal remuneration act, and payment of bonus act. So all these enactments were in existence, and with these enactments, provisions were there in plenty, as I used to refer, that provisions for defining the terms, provisions for fixation, revision, review, provisions for appointment of authorities for administration, in other words, regulation. Prevention is better than cure. Therefore, inspectors are appointed. With the presence of the inspectors, some sort of apprehension will always be there, because they are to submit the returns, and they will face any time what is that the physical form of inspection, wherein we found some physical form of inspection even now being present, but there is also some web-based inspection today. That is the advancement the science and technology has contributed. You be there in the office, and through that web-based technology, you can be inspecting each and every corner of establishments, and to ensure, and you can again, it is the responsibility of the employer or any person authorized by him to ensure that whatever provisions related to these wage code pertaining to bonus, pertaining to wage, pertaining to payment, pertaining to equal remuneration, you have to produce the registers. They may not be coming to your establishment, but they will be there in the office, and through that video conferencing, web-based, they will be requiring you and how it is maintained. And if need, they will call all the workmen to inquire. And workmen should not be the employees different categories employees employed therein should not be apprehensive of anything. They should be bold enough to say how it is and how compliance is, in existence, whether it is safeguarded or compliance is, some sort of compromised. This way, you will have to be clearly. So workers, you are given the opportunity by the inspectors through either physical form or, web-based form. You are given the opportunity, and you should not be abusing this opportunity. And this was not present in the Minimum Wages Act. They used to come and enter and show the identity and examine each and every with respect to each and every four legislations. And then, if there is any contravention happens, either at the complaint of the employee, trade union, inspectors, etc., the inspector can initiate, proceedings before the adjudicating authority, who used to be not below the rank of, the labor commissioner or a commissioner appointed in the Workmen Compensation Act. Such labor officers are authorized in this behalf by the appropriate government. Earlier they used to, and then prescribing of penalties. That's regarding minimum wages. And one more, if you come to this Payment of Wages Act, Payment of Wages Act primarily focus on, it is very much present. Even that practice, malpractice, I can say, even that malpractice present today in every establishment. What is to say that minimum wages or living wage or fair wage, whatever it may be prescribed, are you paying them? When you are showing complaints to the Minimum Wages Act and paying accordingly the wages, whether you are complying with them while paying the wages, because payment of wages earlier used to be, somewhat 50 years back, they used to be paid in the currency. They used to be paid in currency notes, currency coins. But in course of time, this led to some sort of, this led to some sort of confusions, inconvenience. Therefore, they resigned from it and started to, pay it in the form of checks. And then again, advanced form, that is crediting to your account. And now even more, online payment. All these have, surfaced, but whether the payment is whatever prescribed for the work done, whether it is actually paid, is the one question to be seen. Whether physical form or, technology form, you need to ascertain whether Payment of Wages Act provisions are complied with regarding payment of wages, the mode, manner, payment. Then next, the deductions. You show 30,000, but ultimately the take-home salary is reduced to the bare minimum. That because that is the, quantum of deduction. This or that reason they used to quote employers. Finally, they used to pay very less wages, showing compliance, but after having unauthorized deductions, the net take-home pay will be very, very less. This is not, is it not exploitation? This has to be prevented. The Payment of Wages Act had provisions regarding the same, like prosecutions, like inspectors, like adjudicating authorities were there, but still it surfaced. These are the provisions under the Payment of Wages Act. It prescribes a different class of deductions, authorized permissible deductions, and those other deductions affected, then they are called unauthorized deductions. Deductions permissible if you are, if the payment are to be made from out of your gross salary, if the payments are to be made to the, cooperative societies or insurance sectors, towards loans or insurance schemes, then it cannot, the deductions cannot exceed 75% total. I didn't say that it's only, but if at all there, then 75%. In every other sector, it should be, 50%. So Payment of Wages Act had provisions like these to ensure payment of wages are to be in accordance with the wage prescribed and they are properly paid. Then comes to equal remuneration. Oh, this was a real issue. We know that, especially in the field of, tennis, because women in the field of cricket is a new introduction, especially the development of, the later part of 20th century and seriously the newer part of the 21st century. Today, women's cricket is no less as compared to, men's cricket. But in 1975 to 1982, as I remember, there used to be a serious, what is it? Appeal raised by Steffi Graf, Martina Navratilova, Gabriela Sabatini, Chris Evert Lloyd. These were the legends of women's tennis in the 80s, and they raised a serious plea before the Tennis Federation that why 175,000 US dollars for the prize winners, runners up 80,000, and why it is only 50,000 to the winners and 30,000 to the losers in the women's tennis. Tennis is tennis. Why there is a discrimination? There was a time they used to, and you go to this homemade maid workers or coolie workers. There again the discrimination prevailed. Like as I remember, up to 1990 in our village, the male workers were paid 50, 60 rupees. Female workers were paid 25 to 30 rupees. Both the quantum of working hours and the quantum of the work discharged by them are the same, but you are paying less. And even in the government sector, we didn't find, but in the private sectors, we did find, in spite of Equal Remuneration Act, we used to find that discrimination. And Equal Remuneration Act is one point agenda of the then government of India as well, that women shall not be subjected to discrimination. There were international conventions against discrimination on women. And on par with that, we have passed that Equal Remuneration Act in respect of similar and substantive work, unless it is very specifically stated in the legislation. Otherwise, both male and female workers are to be paid equal remuneration. And there used to be provisions in the Equal Remuneration Act regarding claims, the authority, and what is that equal remuneration, etc. And inspectors also appointed to inspect. And within the purview of equal remuneration. And one more enactment, Bonus Act. Payment of Bonus Act. Who would keep proper accounting? One issue, because bonus is always paid out of profits. But even otherwise, there were compulsive provisions where if a number of the employees employed in the industries regarding the payment of Bonus Act, number of the employees employed in the industry should be 20. If it is less than 20, this is the major issue. Application of the act. If you go through the 29 legislations, most of the legislation will prescribe that this act extends to such establishments employing 10 or more, 20 or more. As you see, Employee Compensation Act, not Employee Compensation Act, Employee State Insurance Act, Factories Act, this Contract Labor Act, even this Payment of Wages Act, Payment of Bonus Act, etc. Even Minimum Wages Act, application of Minimum Wage Act provisions applicable to all industries and put together in India in any particular industry, in any particular work as scheduled in the Minimum Wages Act. If 1,000 or more employees employed, it is not necessarily 1,000 or more employed in the same employer, but in whichever employment carried on by different employers in India, if the number of the employees employed therein, if it is 1,000 or more, then it has to be notified that Minimum Wages Act applicable to that employment. Whoever carrying on that employment are to apply minimum wages. The same provision applies even under the new act. Remember, payment of Bonus Act applicable to what is that called? Applicable to 20 or more. All industries, all establishments employing 20 or more. Not government. State or central government employees are not to be covered by this because they have got specialized provisions under the terms of their employment. Other than that, even unorganized sectors are to be paid. But that is a huge challenge in the days to come. How to locate, how to streamline, how to ensure that the compliance of these minimum wage, payment of bonus, and Equal Remuneration Act, as far as my domain is concerned, even it extends to every other labor codes. But the question is how to streamline them. And you have got only one window: inspectors, adjudicating authority, appellate authority. They're all now very much uniform. Whether the presence of their uniformity for all these issues pertaining to payment of wages, pertaining to minimum wages, pertaining to equal remuneration, pertaining to the payment of bonus, among other like gratuity, contract labor, etc., then how is it possible? Where is the time available? The time available is 24 hours a day, and you don't work all the 24 hours. This itself is another challenge. And when we know that payment of bonus act, bonus is payable compulsorily. When it is extended to you, you cannot be reporting like unless you specifically state that you are in serious financial stress on account of some calamities, some lack of demands or market crisis, then okay, if you are exempted, remember, appropriate government upon receiving this particular application, while exempting, you have to be extremely cautious, because if you exempt, the repercussion is that you are depriving the benefits, the social benefits to the workers. That cannot happen. I didn't say that government cannot do. Employer cannot be deprived of. Employer is entitled to the exemption. But exemption granting permission, you have to be extremely careful. Otherwise, it will affect, employer may be a smaller community. Of course, he is the boss. He is the, what is that? He's the, I mean, we are having our living because of the job given. In a way, he's a parent like. In a way, he is the one who is, serving us. So hence, that harmonious relation should exist so as to keep soft, smooth, and qualitative and workable industrial environment. And it is possible when the employer genuinely appeals that I cannot be subjected to payment of bonus act as my condition is seriously very affected, low. And if it is, then in days to come, in the very near future, I may have to close down the undertaking. See, closing down the undertaking on account of your serious financial stress, and no law can compel the employer to go for the loan for revival. You cannot compel. It is violation of employer's right under Article 21. As we have seen, Excelware versus Union of India, Keshava Mills versus Union of India, plenty of cases that are available. All those cases are available equally. People's Union for Democratic Right, Asiad Games, so many cases, so on, as we have referred to. These cases illustrate that there are provisions. They were not in entirely, promoting the interest of employees at the cost of employers. They considered both and gave a fair verdict. And regulators must be aware. You are not regulating it. You are not implementing different legislations so as to boss over the employers, boss over the employment. You are there as a facilitator. You are there as a smooth functionary to ensure what is what is the ambit of law, whether they are complied with. Go there, ensure the compliance, and don't be dictating and be polite to them. You are there for that cause. And we ultimately want this kind of a regulation. We ultimately want this kind of a compliance. And if that is shown, 100%, I'll tell you that employer-employee relationship will prevail. Employer will somehow, in such cases, if you were paying, living wages or fair wages, in such cases, there may be a fresh. It may be a suggestion that I am giving. There may be a fresh round of agreement for the time being to reduce the wages to the minimum, to the bare minimum wages, because instead of losing the job, it is better to sustain the job at the minimum wage level. It may be so possible. It's one of the suggestions that could be given to ensure that employer-employee relationship in employment will keep intact, because that is the need of the hour for them to earn their livelihood. That is the need of the hour for the employer to earn his livelihood as well, to provide, to generate possible re-employment opportunities and new employment opportunities. And it is the best opportunity for the government to ensure that that industry and agricultural sector will not collapse. And government's move must be to make measures in order to sustain, in order to promote, in order to preserve this kind of provisions. And we have that the payment of bonus act compulsion is 8.33, and optional is, I don't say that optional in the sense, it depends upon the profits margin. When it is escalated, you have to increase the bonus rate, and bonus is applicable only to persons who have worked in a financial year for 30 days. And remember, this is one important aspect. You may be saying 8.33 of the basic plus DA, and maximum is 20%. You can pay over and above, employer. If you are having a good financial reserve, definitely pay. Then the relationship will be even better. But no worker can have a claim to demand more than 20%. Then if your basic and the DA happens to be right now, ceiling is 21,000. Say for example, if your basic plus DA is 21,000, you are eligible to claim the bonus. You are eligible to claim the bonus then when you worked for 30 days in that year. You are eligible to claim the bonus on the calculation of 7,000. That is it. You cannot claim more than that, subject to the maximum of 7,000. That's what statute says, even under the new labor code. But what is in practice? Look at that. You salute the employers for the practical analysis. Without going by the statutory maximum limit, they are paying you 8.33, and they are paying you subject to the maximum for 20%. It's a very good move. It's a very good practice that is prevalent, that reduces the conflicts in the payment of bonus act. If you know, the employer and employees, if they are aware of that, maximum limit of bonus will be 7,000. If at all you are aware, then you cannot be compelling the employer to pay beyond. But whether the employer is paying that way, there is good practice showing that, substantively showing that they are paying based on your basic plus DA. They are paying 8.3, whatever declared percentage, from 8.33 minimum to 20%. This is I think one of the healthy practice that we are seeing in actuality, as far as the payment of bonus is concerned. So when a bonus payment is like that, it cannot be denied. And if it is denied, if it is reduced, then recovery process, then there are claim authorities. Now there is a uniformity in the claim authority, not below the rank of the labor officer. You have to have at the central level, not below the rank of under secretary; at the state level, not below the rank of labor officer, maybe labor commissioner, regional labor commissioner. They will be receiving the claims, disposing of. And if you are not happy, then you have time limit to file an appeal within 90 days. And not regarding payment of bonus alone, maybe minimum wage, payment of wage, or equal remuneration, or any. There is uniformity. All these legislations are aiming at minimum wage compliance, payment of wage compliance, pay it within 7 days for the work rendered in the previous month. When upon the conclusion of the working month, within next 7 days, maximum in 7th day, you will have to pay the wages. In what mode? In the prescribed mode, electronic mode, or in the mode of crediting to the account. That's a good practice. You'll have to follow. And if at all it is not done, then comes the claims. Who will entertain the claim? And if you are not happy with the adjudication in the award given by that particular officer, that the claim adjudicating officer, you can appeal within 90 days to the appellate authority in this behalf appointed by the central government or state government, as the case may be. You have provisions in each and every enactment regarding definitions, regarding their own respective objectives, like Minimum Wage Act, Payment of Wage Act, Equal Remuneration Act, or Payment of Bonus Act. Each enactment have got their own objective, and the objective is to ensure that they are kept intact and the workers' interests are not defeated. And it is a earnest responsibility, onerous responsibility of the employer to comply with. And now the compliance has become even more easier for the employer, because he finds instead of 115 provisions in these 4 legislations, since they have been reduced to Indian new wage code, we have got hardly 69 sections in the new wage code and 19 rules framed in this behalf by the advisory boards. And that covers aspects regarding minimum wages, right, regarding payment of wages, right, regarding payment of bonus and equal remuneration, and the constitution of advisory boards. We have all these. It defines wage. One of the most important aspect is wage. Wage is defined. What do you mean by wage? Wage means anything capable in terms of money. But it includes what? In its section, it says, clearly provides, it includes basic, it includes, dearness allowance, it includes retaining allowance. These 3, but does not include, that is, going to a big list. It includes what is wages. Wage means anything which is capable of being determined in terms of money. And that is basic pay, dearness allowance, and the retaining allowance. But it doesn't include 1. What is that? Bonus. 2. Now I'm coming to the details. Bonus is not included. Gratuity is not included. House accommodation is not included. Value of house accommodation, I mean. PF is not included. Then conveyance allowance not included. Then regarding special expenses entailed to the workers or employees, depending upon the nature of employment, not included. Overtime not included. Any remuneration payable by an award or settlement not included. Any commission payable by to the employee not included. Any retrenchment compensation or other compensation not included. Then the question, if it is not included, that exclusion part itself is huge. That is posing serious form of interpretational ambiguities. Why I am telling? What do you mean by wage today? You know that basic and dearness allowance, or so-called retaining allowance, 3, they should be 50%, and other allowances should be 50%. And my dear colleagues, I am telling you, the other allowance will not remain the same. Other allowance will keep increasing. Maybe your housing accommodation value, maybe your house rent allowance, maybe if you are asked to do the work as regards working overtime, you know that normal working hours per day is 6 days, deeming that it is 6 days work. Normal working hours is 48 hours, and you can be asked to work overtime for 12 hours. But this excess of 12 hours will have to be computed at the double rate of normal wages. Don't you think when there is a demand in the industry for labor force, invariably employer will invite employees to work overtime, and employees cannot desist it or reject it. If they reject, then they will invite disciplinary action. 100%. You don't exist only to your convenience. You will have to exist for the employment convenience. As and when there is a demand of excess work, that's a good sign for future recruitments. That's a good sign for your promotion. That's a good sign to get your wage limit increased from one to the next higher level. But if you are not aware of these, if you are not sensitive to these, then you will indulge in these conflicts, disputes. That's not good sign for good industrial healthier environment. It will definitely break the workable relationship between employer and employee. And there need to be awareness, serious awareness. In spite of the presence of so many legislations earlier, there were no awareness. There were some egoist tendencies among the workers, and these workers might not have tempted to raise the dispute, but the trade unions joined hands with because there used to be political influence, and that led to serious form of conflicts. I don't say that today that political influence not there. Maybe some of the establishment may be owned by substantially owned by the politicians, and that will definitely mix this moral elements, political elements also will be mixed. I do not mean to say that the conflicts will not be there in the larger numbers with the introduction of these new labor codes. I mean, especially this wage code, there will be, but it is minimized. That's what we feel. But if our feelings are to come good, then we will have to address all challenges with respect to these four, earlier wage-related legislations, and the present, the new wage code 2019. With respect to these provisions, let me tell you the challenges that are of a serious nature. The provisions may be there, so many, but the challenges are not too small. And these challenges will primarily, consist in dominance of informal sector. I said in the beginning, the working force in each and every establishment of different kinds, whether it is contractual nature or permanent nature, whether it is gig worker, whether it is platform worker, whether it is temporary or whether it is badly workmen or different classes, whatever. The number of the workmen in the informal sector are huge. So when the number of the workmen in the informal sector are huge, this the uniform labor code on wages pose a threat to administration or implementation. With the uniformity of machinery, both at the administrative level, claim adjudicating level, appellate level, you may not be able to. You can't think that whatever problems that have surfaced, whatever claims that you have found are the only claims. There are many other. Is it possible for you to visit each and every sector? Maybe web-based, maybe physical. Is it possible? And whether workers will be inclined to inform you. And these workers, they are informal workers. They are not in any employment. They are freelance. Ola, Uber, Swiggy, then Zomato, and then freelance, technicians, freelance software professionals, then so-called, the outsourced employees. They're all working, and their contribution to the industrial advancement of the country and their economy is huge. But how will you regulate? And whether you are providing each and every, okay, we are now confined in our discussion, I am confined to wage. But if I go to other three, where is that? You are not complying with there is no extra expenditure involved for the employer. And their position is very pathetic. If they work, they will earn. If they don't work, they will not earn. There is no security of employment for them, though they enjoy the freedom, but the freedom of finance is not there. Though, therefore, informal sectors administration and implementation of this labor code will pose a huge challenge. Hope those challenges will be addressed in a smooth way, because country needs all these sectors, and informal sector will remain informal sector, because nobody can force an employer, government or non-governmental, the establishment. Nobody can force them to make them formal. It is huge, because I mean, if at all you force, then there will be no employment generation. And remember, in the past 8 years, I'm telling you, starting from the 2016, the employment generation in India, especially in the industrial sector, has enormously increased. Enormously means enormously, from 32.5 crores to 47 point, and now it is 61 of the total population, maybe around 150 crores of population in India. We have got 61 crores of population in the working sector, whether formal, whether informal sector. Don't you think bringing about these legislations and enforcing it vigorously and rigorously would force them to lose even that informal employment? And you must be the administrators, the appropriate government. You have got advisory boards, and these advisory boards are having representatives from employers, from employees, from the governments, and nomination by the government. Remember, out of these, one third in all related legislations, one third members shall be women, and the chairman will be appointed by the appropriate government, be the central or state government. One more aspect, national floor wage they have introduced. Beyond, I mean, below the national floor wage. National floor wage means the minimum base wage. You cannot be, when the central government has introduced by notification national floor wage under the Minimum Wages Act, it is one of the phenomenal provision, I should say. But will it be possible to enforce it on the states? Because states can prescribe any wage, but it should not be less than the floor wage prescribed by the. That is what I mean by uniformity. Earlier it were not so. Earlier they were entirely dependent upon the state within their sphere, because ours is federalism. Concurrent list, the subject matter of labor or workforce, industrial force, it will come in the concurrent list. Therefore, in entirely, central government cannot dictate the terms on the states. As for the central employment, it is central government. As for the state, within its sphere, state is having the freedom. But I didn't say that the state should be given freedom. Yeah, that is good move, that introducing the floor wage by the central government, and ensuring its compliance to ensure that no wage, minimum wage, no floor wage prescribed by the state in their territory can be below the. That's very good move. It cannot be below the floor wage. But will it be possible for the state? Whether the state is prepared? And we are yet to see many states notifying it. We have not seen that a state government implementing, though we have the implementation scenario in picture, but state government will, I mean, if they introduce, then so many sectors, whether formal or informal, they will face challenges. Employers, it is not state government or central government paying the salary or wages. It is a employers, whether MSME, whether it is a medium scale, whether large scale, the employers paying. And if you introduce all of a sudden in their infancy stage, the legislation is, if you all of a sudden introduce whether they are prepared to pay that, don't you think it's a financial burden? And if such a legislation there, by my argument, I do not mean that you must leave the freedom to the states. I mean to say, but have a smooth enforcement. Here and there is unintended contraventions, but you need correction. Though we have provisions, the inspectors upon inspection of records and registers, because there is no uniformity in the maintenance of registry as well. In the register, you have to mention various aspects as far as the wage code is concerned, minimum wage prescribed, by what when it is introduced, when it is revised, etc. You have to contain in the register. And what is that minimum wage pattern? Whether you have different scale of wages like minimum wage, living wage, fair wage, as for the bonus, as for the equal remuneration, etc., etc., you'll have to contain in the register. He will see the register, but just to seeing the register, imposing hefty penalty, no, he is unable to pay the floor wage prescribed by the central government, and it is to be followed by the state government. So when employer is unable to pay the floor wage itself, then if any violation or contravention is found, how is it possible for the employer to pay 50,000 penalty? Remember, if the penalty recurs within the period of 5 years, then it will be attracting penal provisions. What is the penal provisions? You'll be prosecuted. Second time, if you commit in the period of 5 years, you'll be prosecuted. It will be considered as offense, and you'll be subjected to imprisonment ranging from a month to 6 months. 50,000 penalty, or with both. Will it be possible? No, it will always have some sort of a forward. I don't. There will not be a forward thinking. There will not be an aggressive, progressive thinking on the part of employer to further the employment. Instead, he will consider, I have started up this employment, but the legislation doesn't allow me to be peaceful. And it says that you have to pay this kind of a floor wage. Central state will plead its excuse by saying that, hey, sorry, sir, central legislation has already mandated it that it cannot be below the floor wage. But these employers are unable to do that. They will close down. Whether the objective of the very legislation on wage code, whether it has sustained its objective, sustained its true spirit, whether it has promoted, question of sustenance, question of implementation, question of sustenance, question of promotion will not arise. Instead, we have generated huge employment, but those employments may be waning. And when the employments are waning, reduced, then it will affect economy. It will affect a likelihood of living, in a basic cost of living, basic ambience of living of everyone getting affected. Need not be alone the workers, but even their families. Then we'll be confronted with the poverty, and this will lead to, when there is poverty, that's the beginning point of every other calamities like illiteracy, unemployment, everything, and even crime. Ultimately, it will go to the extent of crime, because I am born, Vijay sir. When I am born, I have to live, and if I have to live, then I have to commit offense, violations. Is it the objective? So beware of all these while implementing. Implementation has come, provisions is good, but whether it is viable, and regarding its viability, sincere efforts should be made by the governments. Sincere efforts, and there should not be any mixing of politics in this. Whether it is owned by you or me or the governors, the bureaucrats, the politicians, it doesn't matter. But the compliance law is, because we are governed by law. Law is sovereign, and posing the threat itself is this, that we may have to lose so many employment in informal sectors, may be suffering here and there. Papa, they are great enough, generous enough in discharging their work and earning their livelihood. But if you bring about these legislations all of a sudden, probably that may be hitting their pocket. That is a challenge. And then we have that, regarding, definitions. As I said, wage is defined. It includes and it excludes. List of exclusions are more. But there is one serious threat. The list of exclusions are more, but whatever excluded, whether it is bonus, whether it is house rent, whether it is conveyance allowance, whether it is overtime, sir, when overtime allowance, or what is that, conveyance allowance, or so-called bonus, or traveling allowance, etc., will not remain the same. It will keep increasing depending upon the cost of living. When it escalated, yes, as you know that to the government employees every year, they are increasing twice the dearness allowance, something like that, when it increases. So you have structured, the employer has structured in the beginning to comply with the wage code, so as to see that 50% of the total wages shall be basic plus, basic DA and retaining components, and other 50%. But I am telling you, dear colleagues, whether other 50% allowances will remain the same. They are excluded from the wage ambit, but they are included for tax calculation. Of course, the gratuity is not calculated. The other allowances are calculated for a tax calculation, income tax purpose, but not for wage calculation. Remember, this will have negative repercussions, a negative impact on various other legislations like maternity benefit, employee state insurance provisions, then Employee Compensation Act. Then we have got a provident fund. We have got plenty, even gratuity and bonus. All these gets affected. But the law is so good. The present wage code is so good. When other allowances, for example, how many days, if I being a worker, how many days I work in a factory, extra time, overtime we call, that cannot be anticipated. But as I said, 12 days in a 12 hours in a week, I may be asked to do extra work, overtime work by the employer. Fine, good. But when I work overtime, what is the wage drop? Double the rate of normal wages. Therefore, don't you think my other allowance, what you have excluded, overtime allowance, you have excluded value of house accommodation. When the value of house accommodation increased, depending upon the cost of living, when the traveling allowance increased, depending upon the cost of living, or escalation in transportation prices, or when there is an increase in a housing allowance, whatever paid to you, since the rental rates have gone up, or whatever overtime hours, if you're asked every week 12 hours, and of course, there is a cap per quarter, it cannot exceed 125 hours. Everything is now capped, but you are working extra, and obviously, the exclusion of these from the ambit of wages. And finally, they contained a provision like the other allowances cannot be more, I mean, basic wages should be 50%. Other allowances cannot be more than 50% of the total wages. But when overtime, house rent allowance, etc., are increased, then other allowance will increase. Never mind, when it increases beyond 50%, then all the increase will have to be added to the basic wage, is what we find one provision under the new wage code. Therefore, the answer is there. But will it be answered by the implementing employers? Because all that needs money. Therefore, interpretational issues, litigations will come forward. Then we are living in a federal structure wherein they say states, I don't bother about implementation. I am given the freedom. If there is a conflict prevails among the center states, the smooth relations of center-state relations will be affected. And if they frame not in keeping with the central, then don't you think serious conflict will prevail between center and the state governments? Don't you think that conflict will complicate the standard of employment? Employer and employee are getting affected. This will be there. Then we have got awareness. That's another. Oh, we have all these legislations, but how to bring about awareness? So therefore, you have implemented, but it requires some time for implementation. So take time, because implementation will require some sort of mechanism, smooth functioning. You cannot bring all of a sudden. Maybe employers and workers are not prepared. Maybe employers and workers need to be trained, need to be made aware, need to be very sensitive towards these provisions, and need to be focused on the employment so as to cope up with these the changes introduced. When the returns are high, then definitely it is possible for the employer. So give them time. That is a suggestion. And then regional disparities, gender-based discrimination, etc. They need to be looked into. And the rise of gig and platform workers need to be looked into, because their percentage of their percentage in the employment sector is huge, so huge that even formal sector doesn't come to their level. Therefore, they need to be taken care of, and they should be preserved of their employment. And one more issue that may be surfacing is regarding the what is that called under the new labor code. We have inspectors, correct? When there is a violation, he will impose a penalty of 50%. And if it is recurring within the period of 5 years, within the period of 5 years, my dear colleagues, if it is recurred, then he will attract a penalty. I mean, punitive measures. That means he will be prosecuted. See, whether these authorities, our adjudicating authorities, whether they are trained, It's a new enactment, new provisions. And remember, all these sectors are included. Remember, you have to have the knowledge. And you are leaving the education in the first instance, penalty, this, etc., with the administrative agencies like commissioner, labor officer, etc., having no judicial experience. Probably that may be hampering the proper decision making. The award making process may be, affected. And one more thing, who is still dominant? It's employer. When the employer is dominant, the law requires, in case of violations, a law requires employer to deny. The burden of proof is upon him, and collecting the proof favoring the contravention may be another issue, because in terms of litigation, it's a skill level that matters. So we have different skill level among the professionals in law. So you need to be taking care of that as well. And the challenges may be even so many. As I said, the inspectors come facilitators, whether they are trained well enough to introduce, whether they are trained well enough to be sensitive to the employment, to the employer and employee, because now they are no more inspector. There is Inspector Raj is gone. It is said Satyameva Jayate. Now it is Shramameva Jayate. And it is said one more thing regarding e-Shram. We have got that digital mode. You can bring about the complaints regarding, but whether the complaints are genuine, it may be web-based. I said, you don't have to physically submit. You can, the phone numbers are available at the entry point. If there is any claims, complaints, you can file in by mailing that, etc., to the number, to the mail ID, etc. Whether that will be addressed, whether the truthness of the complaint could be examined that easily. That's another enforcement provision. Enforcement limitations, dilutions. These may be posing serious challenges. So I cannot dwell more on that, as it is the time. I have dealt with some useful, most significant challenges that these provisions under the new labor code may be posing regarding definition, regarding advisory board components and their functioning, regarding still they will be only advisories. Whatever their suggestions are only advisories. So these need to be taken care of. And taking care of or addressing all these requires some expertise in the matter. Taking care of all these matters will require some sort of sensitizing all the concerned, because ultimately the penalty or punitive measures will not be the answer. If that is only the answer, then it is not a welfare. It is not a welfare society. It won't be the objective of the industrial environment as such. As you know, that the main intention of this particular code is to, it is stated, is to consolidate the law relating to wages, bonus, and related matters. As I said, the related matters are nothing but payment of wages and the other, what is that called? Equal remuneration matters. There cannot be any gender discrimination. It intends to simplify, amalgamate, and rationalize relevant provision of the four central critical wage laws as prevailed earlier to make it one new comprehensive labor code on wages. The provisions are good, seems to be, because there is now no overlapping. And for all administration of whether this or that, we have got one independent, one uniform, one simplified labor code, that is code on wages. Doesn't mean these provisions are very harsh. These provisions are quite alien to the industrial environment. They are good, but its implementation will require to address all these challenges. I hope you have understood. If there is any query, yes, you can bring about. Thank you for patient hearing.
Thank you so much, sir.
Thank you, sir.
Vijay,
Thank you, sir.
Uh,
Under the new labor code, specifically the Code on Wages 2019, the previous wage laws have been consolidated and modernized to create a more streamlined framework. This code aims to ensure fair wages for all workers and addresses various aspects of wages, regulations including minimum wages, payment of wages, and concept of equal pay for equal work. Sir, your discussion on the implication for compliance and the need for awareness among employers and employees is crucial as we navigate these changes. Once again, thank you very much, sir, for your enlightening session. It has truly enriched our understanding of this important topic. Now the session is open for the discussion. Dear participants, if you have any questions, any queries,
There are some
you
questions
can
in
ask
the chat box.
resource persons. Yes, sir.
Sir,
There are
one minute,
some questions.
Yes, yes.
Yes, sir.
Yes, sir. Sir, there are some questions in the chat box. The first question is,
Yes, sir. Yes, sir.
yes, sir, yes, sir. As per the new code, new concept of floor wages is added. Please explain how is it to be decided as per the geographical areas?
Yes. As you know, regarding the skill level, regarding the area, regarding conditions, regarding nature of employment, the prescription of minimum wages are different. As you know, highly skilled, skilled, semi-skilled, unskilled. Not only that, no, these unskilled labor force exist in various sectors. But if that is remote area where they are employed, obviously you cannot be prescribing the minimum wage limit just like as it is in the advanced sector like cities, towns, and all. So, and one more, the nature of employment. What skill is required from the employee, whether it is skilled, whether it is unskilled, whether it is highly skilled, whether it is techno skilled. No, it depends upon the floor wage cannot be the same. Floor wage differs on the basis of skill level. And when the floor wage is prescribed, national floor wage is prescribed, say for example, highly skilled workers, highly skilled employment, they will prescribe one floor wage. That is the base level of the minimum wage. And no sector, no employment carrying on that skilled employment, highly skilled employment can pay less than that, whether at the central level or even under the state level. So, prescription of minimum wages or floor wage, depending upon the, as you said, the nature of employment, geographical conditions, and the skill level that the job demands. So, obviously, that is already addressed. As I said once again, even when it is addressed and it is defined, the state government, depending upon skilled, unskilled, highly skilled, or semi-skilled, when the floor wage is prescribed, the state government, while on implementation of these wage laws, they cannot be prescribing less than that. It's a challenge. It's a challenge. Whether the state government, it will involve definitely if the state government goes ahead with the introduction of a floor wage as prescribed, mandated under the central legislation, then I think some political repercussions may be there. Their party may not be, the party in governance may not be coming. So therefore, whether the state government will venture, that has to be seen. I don't think the state governments will give a clean go. They will decide on this, work on various aspects, and then prescribe the the compliance to the said floor wage limit. Of course, it varies depending upon the nature of employment, conditions of employment, the geographical area, and all. But there, the challenge is very much there. Significant challenge is very much there regarding implementation. So we are still in the infancy stage. It's about today it is 6th month. It's about 7th or 8th month we are going in. It will take time, and I don't want the informal sector to remain informal sector forever. They should be coming to the formal sector, and it is earnest job of the government as well to promote informal sectors and not to make them retain their status of informality, informal till the end. Somehow the government will have to, through legislations, through encouragement, through proper economic transactions. The government should ensure that they are inflated to the formal sector. Otherwise, their problems will continue to remain and suffer. Right, sir?
Sir, another question is, bonus need to pay on 7K or minimum wages, whichever is higher.
A bonus need to see, sir, regarding the payment of bonus as per the earlier enactment, as per the present code on wages. The requirement is that who is eligible to claim the bonus? The person who is ceiling limit 21,000. That is the ceiling limit. One. And if it is going out of ceiling limit, then he won't be. One. Two. Subject to the maximum 7,000 per month. That means 84,000. No. Subject to the maximum 7,000 a year. Not 7,000 a month. Subject to the maximum 7,000 a year. But I am telling you,
sir,
what was in...
It's an observation made.
Yeah.
Sir, it is 7,000 or minimum wages, sir, whichever is higher, as per the section 26(2).
Yeah. Yes, sir. Minimum wage, not minimum wage, sir. Ceiling limit. 21,000 is the ceiling limit.
No.
Who are eligible? As per the Bonus Act,
No,
all are eligible.
No, sir. I am not talking about eligibility. I am talking about
Okay.
calculation.
Calculation, sir. I am telling you, I will come to that real practice. But I am telling you that you cannot be claiming more than 7,000. That is what the statute says. Of course, there is a choice.
No, sir,
what is the minimum wage limit?
As per 26(2), it is minimum. It is 7,000 or minimum wages, whichever is higher.
Correct. But what is in practice? It is not in practice. It is a law. But as we see, mostly significantly prevalent is the 8.33% of your basic plus DA. Whether it is 21, whether it is 28, whether it is 50, they are continuing to pay. And the real practice of the companies, corporate houses or industrial sectors, they are paying not this base limit minimum. They are paying as per the basic plus DA retaining allowance. So whatever wage is defined under the wage code or under the earlier existing legislations, they used to pay. And even now they are paying. I am seeing it quite evidently. I am seeing it that they are paying the bonus at 8.33 of whatever total they have earned basic plus DA in a year. Of that 8.33 or whatever from time to time employer decides whether it could be subjected to the maximum 20%.
Yes. In practice, they are paying like that, on 7,000.
Yes, sir. Yes, because if we refer to the code or if we refer to the earlier existing legislations, it came to my surprise by knowing that 7,000 or minimum wage, whichever is higher. It came to my surprise because it never used to be in practice in most of the sectors where bonus were made applicable. Right, sir?
Yes, sir. Shilpa madam has a question. The new wage code requires basic pay to be at least 50% of total wages. How can employer comply with this requirement without significantly increasing their PF, gratuity, and other statutory liabilities?
Yes, you're talking about the new labor code. Yeah, under the new labor code, suppose, for example, if my total pay, basic dearness allowance, other retaining allowance, and other allowances are not included actually in wages. If my total pay is about 60,000, then law says under the new code. Earlier there used to be some sort of not fair practice. Earlier there used to be, I'll tell you, there used to be basic pay of 15,000. Dearness allowance of 10%, because these are the wage components that are considered for calculation of many things like gratuity, like bonus, like minimum wage, like I can't illustrate all of them. But now the government, in a fair move, they have decided, see, come what may, you cannot, with the introduction of this new labor code, dear colleagues, you cannot reduce the wages that they were drawing earlier to the commencement of this code. You cannot at any point of time. And what is their wage? As I said, my wage is 60,000 total, the gross. And out of that, 30,000 should be basic and dearness allowance. That should be, and other allowances, as I said, whatever you are giving, utility allowance, telephone allowance, traveling allowance, conveyance allowance, housing allowance, overtime allowance, it should be 50%. So at any point of time, ensure that the law says The other allowances cannot be more than 50%. Basic wage should be, basic plus DA should be at least 50%. Cap is imposed. But once again, in the course of my explanation, I offered saying that the other allowances are bound to be increased. You cannot say how many days I have worked overtime, and you don't compute that. When you earn extra, in the other allowances part, like housing allowance, like a traveling allowance, if it gets increased in the next month, my wage will move to 65,000. Then what? Whether you will make it as 32.5? No, you will make basic plus wage should be whatever in excess of the 50% of the wages. Earlier, your wage limit is capped. 50% in excess, if it is there, it will be added to the basic plus. It will be added to your basic plus DA. That is wage. And that will be helping the employees. I know your part is very good. That some employees, large scale, especially in the informal sector or in some weaker or SMSE or middle formal sectors, they may be objecting to this because they will not be significantly aware of their future position. They'll be interested in only knowing about the present position. Their take home will be reduced because the amount of pay that amount of reductions going towards gratuity, going towards ESI, going towards PF, going towards other things will increase. Therefore, take home will be less. They will be thinking. But remember, all these going towards for your social security, to secure your safe future. That you must be conscious of, employees. And as such, definitely it will have some impact on take home. It will, all the employees, as a result of the introduction of this, they will have little lesser take home. But it will not go beyond them. It will come to them in a lump sum way in the future. So I don't think that will be impacting. And the answer is very much there. By if there is any increase at a subsequent stage in the other allowances, the increase will be added to the wage description, that is basic plus DA something. So that will entail some sort of benefit to the employees. I don't think benefit should be reality. It is some sort of a privilege that employers should consider. They might not have intended that future savings, but it is good for their future.
Jaikumar sir has a question. What is the retrenchment rule in the new wage code 2019?
This retrenchment layoff rule seems to be little disadvantageous to employees.
Yes, sir.
Reason, there is a cap. That 300 employees. This up to 300 employees, these provisions are not applicable. Are not applicable. Beyond 300, yes, it is applicable. Then regarding retrenchment, regarding layoff, regarding closure, employer can have his own definition. Don't you think that will not give enough protections to the employees? They might go on to lose their job without secured provisions. So that way it is, they consider probably in the days to come that may be addressed seriously because the object of the law, first of all, we have to see the preamble of the wage code. And considering the preamble wage code, there obviously when the enactment is in its infancy stage, everything cannot be predeemed. It has to be addressed as and when the maladies or as and when the hurdles in the implementation course come into surface. We will, the legislators, the policymakers surely address this in the days to come. And the intention of wage code is not to cause mischief. It is to address the mischief and provide the remedy. Of course, at the present level, some level of employees may be suffering.
Nargun sir has a question.
Yes, sir.
What is set on and set off under wage code?
Set off and set on under the wage code. Yes. Concerning what matter? I will tell you concerning what matter. If it is relating to deductions, if it is relating to absence from duties, set off and set on, carry forward, set off, carry forward. That rule is very much there in the Income Tax Act, and that rule is very much there with respect to what is it called, Employee Compensation Act. Half monthly payment is paid to employees. He suffered an accident and therefore is under treatment. And when he is under serious treatment, he will not be paid salary because he won't be doing any work, and he will have to apply to the employer to provide half monthly payment paid. And within 4 months of treatment, it is cured. He is back to work. I don't know whether he will possess the same skill or different skill. When he is back to the work, then he will be paid compensation because he is out of the job. And from the compensation amount, this will be set off. Whatever subsistence allowance that is paid to the employees, this will be set off. And employee cannot freshly demanding whatever compensation applicable for that kind of a disablement or that kind of the cost, etc. They will have to be addressed. Am I audible, sir?
Yes, sir. Yes, sir. You are audible.
Yes. Because I had a call, I connected. So for a while, once again, so they will be set off. And as such, this will lead to some sort of a reduced compensation. So how to address this? Even concerning the wage payments. 100%. I think this will primarily occur relating to payment of wages, set off and set on. Deductions will be made, and you have gross payment like this, but there is unauthorized absence, there is negligence in conducting the business, conducting your work, leading to damage to employers' properties. So obviously that will be or whatever advance that is paid to you. It may be so possible in the work. There are some employers, to meet the contingencies, they provide advance payment, advance wages. And when the time is due for the payment of wages, whatever advance you have derived, that will be deducted, but not in the full form. Say, for example, if my wage is 60,000 per month. So in a month, due to my, some crisis, some need, I have borrowed advance payment of 60,000. So this advance salary that I have taken will be deducted by the employer in the agreed installment. What is that agreed installment? They may allow like 6 months, 10 months. So it will be set off. You will not be paid full wages. You will be paid by deducting that. Whatever loan taken, whatever you have damage caused, etc., this will be set off. And you will not be entitled to full wages as per the, what is that, payroll.
Yes, thank you, sir. May I now request Srimati Nirmala P. Hegde, Assistant Professor, Vivekananda College of Law, Bangalore, to propose vote of thanks.
Good evening, everyone. As we come to the end of today's enriching session, it's my privilege to propose the vote of thanks. First and foremost, I, on behalf of our institution, express my heartfelt gratitude to Professor K. Shivaprasad, Registrar, Ramaya School of Law, Bengaluru, for delivering a highly insightful and thought-provoking lecture on Code on Wages 2019, the challenges of codification of wages law in India. Sir's deep understanding of labor laws, practical insights, and lucid presentation made the session both engaging and intellectually enriching. We are especially delighted that today's resource person is a valued former colleague of our institution, and we sincerely appreciate his willingness to share his expertise with us. It is indeed a matter of pride and happiness to witness his continued contribution to legal education and academic administration. Thank you, sir, for generously sharing your knowledge and expertise with us. I extend my sincere gratitude to our management and our principal, Dr. K.B. Kempegowda, sir, for their constant encouragement, guidance, and support in organizing this faculty development program every year. I also express my heartfelt thanks to Dr. Vijay A.N., Program Coordinator, for his meticulous planning, coordination, and dedicated efforts in ensuring the successful organization of this program. I extend my sincere thanks to Dr. Bhuvaneshwari S. Kolaki, IQAC Coordinator, for her valuable support and continuous efforts in organizing this academic initiative under the aegis of IQAC. I also take this opportunity to thank all the teaching and non-teaching staff of our institution for their cooperation and support in making this program a success. Finally, I extend a warm note of gratitude to all the participants, including principals and faculty members from various institutions. Your enthusiastic participation, keen interest, and active engagement have greatly contributed to the success of today's session. Thank you all once again. We look forward to your presence at tomorrow's session. Have a pleasant evening. Thank you.
Thank you all.
Sir, dear participants, there is a small changes in the tomorrow session. Instead of Johnson, sir, Anish Pillai will be the resource person. Thank you. This is
So,
for your
Prasad
kind
sir,
information.
thank you so much for your enriching
Thank you,
knowledge
madam.
and
Thank you.
sharing the views with us, sir. Thank you so
Thank
much
you.
for
Thank you.
joining with us and accepting our invitation. Thank
Thank
you so
you.
much,
Thank
sir.
you, madam.
Thank you so much. Thank you everyone for joining the session, and we look forward your participation tomorrow at the same time. Thank you so much.